Good evening.
Good evening.
Good evening.
Good evening.
It's great to see all of you. We have an audience here in our foundation room, but we also have 170 people who RSVP'd who are online. So even though this room may not be as full as you'd like it to be, it's still full. There's a whole bunch of other people out in the world watching and listening to this program. So I want to welcome all of you to this program. And it's called Free Speech and Hate Speech, Where to Draw the Line. So I'm Leonard Baines. I'm the Dean of University of Houston Law Center. I've been Dean for almost 10 years. And as Dean, I have to brag about the Law Center first, right? So one is we have 10 top 50 programs. So 10. And 3 are in the top 10 by US News and World Report. Our part-time program is number 6. Our intellectual property program is number 6. And our health law program is number 9. During my 10 years as dean, the median LSAT has increased from 159 to 161. 161 is 80th percentile, meaning if you remember from SATs and LSATs, percentile means you've done better than 80% of the people who took the test, right? Our median GPA increased from 3.47 to 3.71. So the school has been moving in a very positive direction. And the last thing is on our July bar exam, almost 90% of the students passed the first time. So give a round of applause to our students and our school. And we're very pleased to co-sponsor this event with the College of Liberal Arts and the Department of Modern Languages and the Middle Eastern Studies Department for this very important discussion, and to collaborate with Professor Emran El-Badawi and his assistant, Ms. Anashe Sadiq. Let's thank them also for their support. And most importantly, for our underwriters of this program, the Bonawak family and the Charitable Foundation. Thank you for your support. First Amendment is so very important these days, and even more important than it may have ever been. And so it's really great for you to support this program. We really are very thankful. And many thanks to our panelists, our UH General Counsel, Donna Cornell. And I'm just going to introduce them, and then Professor El-Badawi is going to actually do their full bios. UH Law Professor David Dow, Thurgood Marshall Professor Shlomo Pill, and Thurgood Marshall Professor Larry Whedon. Let's give them a round of applause. And our 2 moderators, UH Law Professor Emily Berman and class Professor Emran El-Badawi. Let's give them a round of applause. And why this conference and seminar is so important, because I think what the purpose of academia is to educate. That's what academia is all about. And it's really important for us to provide information about really important issues and to provide light, not heat, on these important topics. So I've been asked to do a brief overview of the First Amendment of freedom of speech and hate speech. So let's put the First Amendment up there. So you can see the First Amendment is kind of brief, and the part that really focuses on speech basically says that Congress shall make no law abridging the freedom of speech. And there's other parts of the First Amendment looking at freedom of religion, freedom of press, freedom of assemble, but that's the language of the First Amendment specifically dealing with speech. And so the question today is about how does it interact with hate speech? So I think all this starts with the First Amendment. The First Amendment broadly protects the right of speech. And free speech means that it's free and that it's public expressions of opinions without censorship, interference, or restraint by the government. U.S. Supreme Court has characterized these rights as fundamental personal rights and liberty, and noted that the exercise of these rights lies in the foundation of free government by free people. The Supreme Court has said that the freedom of speech embraces the liberty to discuss publicly and truthfully all matters of public concern without previous restraint or fear of subsequent prosecution and punishment. However, the level of protection is not limitless. As stated in a concurring opinion by then Chief Justice Warren Burger, he says, numerous holdings of this court attest to the fact that the First Amendment right does not literally mean we are guaranteed the right to express any thought free from government censorship. These exclusions, as you may know, deal with obscenity, defamation, fighting words, and also incitement. Those are exceptions and exclusions from the First Amendment. And the panelists may go into more details on that. Plus, government can place reasonable place and manner restrictions on speech, meaning that they could say, for some things at UH, that it has to be a certain time, have different location, it has to be somewhere that doesn't interfere with what's going on at the university. The Supreme Court refers the right to speak about openly violent action and revolution in broad terms. It says, our decisions have fashioned the principle that constitutional guarantees of free speech does not allow a state to forbid or prescribe advocacy of the use of force or law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite such action. One aspect of free speech that's important for us to note is this fairly, I guess, obscure 1952 Supreme Court opinion called Beauharnais versus Illinois. It's a Supreme Court opinion that upheld the constitutionality of Illinois' group libel speech. So in this case, it punished expression attacking the reputation of racial, ethnic, and religious groups. The defendants were charged for distributing a leaflet that rallied white people in Chicago to halt the further encroachment, harassment, and invasion of white people, their property, and neighborhoods and persons by African Americans. That's a quote from the court. The Supreme Court ruled that libelous utterances are not within the area of constitutionally protected speech. It did not matter the speech did not incite any direct harm. So the court here, which is an opinion from 1952, said that if it was a libelous attack on a group based on this Illinois law, that would be permissible and not would be constitutional. But generally, hate speech in the United States cannot be directly regulated by the government. The Supreme Court has affirmed this in several different times. And for instance, the federal courts and Supreme Court have allowed free speech rights of Nazis in 1977 who were denied a permit to march in Skokie, Illinois, a village where many Holocaust survivors lived. Also, burning crosses were protected and held constitutionally permissible. And that's so the extent of our free speech is very, very broad. And so although hate speech alone receives constitutional protection, any expression that constitutes a true threat, right, a true threat of incitement to imminent lawless action, discriminatory harassment, or defamation can be punished. Private institutions generally have more leverage to limit speech than the government or government institutions. But some scholars have critiqued this, and they call it First Amendment orthodoxy. And they argue that only a history of racism can explain why defamation, invasion of privacy, and fraud are exempt from free speech guarantees, while racist or sexist verbal assaults are not. They talk about hate speech from the context of words that wound, that hate speech can be words that wound, these particular scholars. The First Amendment is our pillar of democracy, but we need to keep in mind that those who drafted it over 200 years ago were rather homogeneous. But today's world is much more heterogeneous. And the question is, like, would our founders, our framers of the Constitution, would they actually draft the First Amendment as it is now? And would it be interpreted as it is now? And the other thing to keep in mind in terms of the change in the past 200 years is that we have social media, which is widespread in terms of its impact and implications for our world. And so speech that's hate speech in the past might have been hate speech that was limited, to a group or whatnot, a small group. But today, through technology, it can be worldwide and may have an abusive effect on many people. And none of this was contemplated by our framers. And I'm not advocating for any position on any of these. That's not my role. I'm just outlining some of the issues that I've seen with respect to this. I'm just teeing up the conversation, right, for our august panelists to address. There's also been several examples of dealing with freedom of speech where they've been contested today, and some of them involved, campus speakers who've been heckled. You probably have seen some of that, and some of it has been, some states banning what can be taught in the classroom. And so those are interesting changes in terms of what's focused on, and I think some observers would say that, this is a challenge and a problem for our society. And it might be a question of like, how do we have different viewpoints? Because when you have different viewpoints in a classroom or anywhere, it allows people to sort of see both sides of the issue. These are issues and questions for our panelists to analyze and discern. I'm very glad that they're here. And I now leave it to Professor El-Badawi to take it from here. Thank you.
Thank you so much, Dean Baines. Hopefully everyone can hear me and can see me. I'm always cautious about that. Thank you so much again, Dean Baines, for putting the UH Law Center on the map and keeping it on the map. We're incredibly grateful and impressed to enjoy your hospitality, and that the UH Law Center is co-hosting this fourth and final summit. So my name again is Emran El-Badawi. I serve as chair of Modern and Classical Languages here at the University of Houston, where I'm also faculty of Middle Eastern Studies. I'll try and abridge my introduction a little bit in light of Dean Baines' comments. So on behalf of course, the UH Law Center, the College of Liberal Arts and Social Sciences, Department of Modern and Classical Languages, I welcome everyone. This is the fourth and final summit examining hate speech as a global crisis. And a couple of words about the project itself. The project, including today's proceedings, is a cutting-edge international study on the most urgent hate speech challenges facing the world today. It's comprised of 3 parts. 1, media contributions by experts educating the public on global hate speech awareness. 2, 4 hybrid summits. This is the 4th one. And 3, a book publishing the proceedings and findings to be utilized as a resource for policymakers, researchers, and informed public audiences. That's the goal behind the whole project. It was 2 years in execution and 2 years prior in planning. And the project, of course, wouldn't be possible without the Banyuks who are with us today. And what I'll do is I'm going to mention lots of people. We'll thank them all the way at the end, if everyone permits. So, of course, in the audience, of course, is Dr. Milton Banyuk, Mrs. Lori Banyuk, and Deborah Banyuk, their daughter. Their philanthropy has nurtured so many causes, including interfaith dialogue, publishing, education, and programs at every level, and has supported many institutions, not least, of course, Rice University, the University of Houston, among many others. I also want to offer some thanks. I want to offer abundant thanks to Associate Dean Saundra Tennessee, my project assistant, Anusha Siddiqui, Jim Tyler, who is not with us today, all right, he's busy, but without him, the project could not have taken off. And of course, I would like to introduce our panelists now. And a full bio really wouldn't do them justice. Forgive me, an abridged bio, which is what I have now, is still not going to do them justice. But I'm going to attempt it anyway. First, I would like to introduce Donna Cornell, General Counsel of the University of Houston, who became Vice Chancellor for Legal Affairs and General Counsel for the University of Houston System, and Vice President for Legal Affairs and General Counsel for the University of Houston in 2002. She's responsible for legal services in all areas, including contracts and conveyances, employment law, constitutional law, real estate, intellectual property, federal research, tax, gift matters, governance, open government issues, and other matters applicable to higher education law, including Title IX. She's also served as an adjunct professor at the University of Houston. Her prior appointments include, there's so many, Deputy Chief of General Litigation Division for the Texas Attorney General's Office. She's partner at an Austin-based law firm and Assistant Attorney General from 1987 to 1992. Cornell earned her undergraduate and law degrees from the University of Texas at Austin. Prior to receiving her law degree, she served as committee clerk and legislative aide in the Texas legislature. So that's one. And I remember talking to General Counsel Cornell. I mean, every day is batting numerous cases, all of which are of consequence. I'm an academic and I get to work in the world of theories, but she protects U of H from a number of unwieldy things. So thank you for that. Next is David Dow, Cullen Professor of Law at the UH Law Center, who joined the UH Law Center faculty in 1988. He dated himself on the website, it's not my fault. Upon graduation from Yale Law School, he clerked for the Honorable Carolyn Deneen King, judge on the United States Court of Appeals for the Fifth Circuit. Professor Dow is also the founder of the Texas Innocence Network. Often working with UH Law Center students, he has represented more than 100 death row inmates in their state and federal appeals. His areas of expertise include contracts, constitutional law and theory, and the death penalty law. He has written extensively on these subjects, as well as on equal protection law and literature and federal jurisdiction. Extremely interesting and existential, shall I say. Next is Shlomo Peel, assistant professor, Thurgood Marshall School of Law. He currently teaches torts, law, and religion, conflicts of laws, and other topics, and his research focuses on the intersection of Jewish, Islamic, and American law and jurisprudence, subjects which are particularly interesting to me as a professor of Middle East studies, as well as American religious liberty and the relationship between law and spirituality. Prior to this, he was faculty at Emory Law, where he also received one of his law degrees, and he was also scholar at the Center for the Center of Law and Religion, where he also served in the capacity of director, managing editor, and many, many other roles. Professor Peel is the author of more than 24 academic articles on law and religion, and a frequent lecturer in academic and popular settings. So welcome, of course, Dr. Peel. Next is Professor Darnell Whedon, Roberson King Professor of Law, Thurgood Marshall School of Law, who is a prolific scholar of constitutional law with expertise in civil rights, election law, torts, criminal procedure, school integration, and immigration law. I hope everyone's keeping track here, I don't know. Okay. A frequent speaker at universities and law schools, Professor Whedon's scholarship has made a significant contribution to the legal profession in a wide variety of subjects. His posts have included that of professor, interim dean, private practice, among others, and his prior appointments include those at Southern University Law Center, Baton Rouge, Louisiana, North Carolina Central University School of Law, Antioch School of Law at Washington, D.C., and finally, he's published dozens of articles. I started counting and I lost count, you can imagine, okay. Professor Whedon received his law degree from the University of Mississippi School of Law, so welcome, of course, to Professor Whedon. Finally, I would like to introduce my distinguished co-moderator, Emily Berman, who is the Royce R. Till Professor of Law at the UH Law Center. Her scholarship examines the unique separation of powers challenges that arise in the constitutional, statutory, and regulatory regimes governing national security policy. Her prior appointments were at Brooklyn Law School, New York University School of Law, where she served as Furman Fellow, Katz Fellow, and many other roles as well. After graduating from law school, Berman clerked for Honorable John M. Walker, Jr. Of the Second Circuit Court of Appeals. Berman's work has been published in top journals and in the media. There are many examples here. I'll just mention, I'll mention CNN, okay, because the others are, there are too many. And of course, Berman teaches national security law, foreign affairs law, and constitutional law. So ladies and gentlemen, please welcome our panel. A couple of quick announcements, then I'll sit down and join the panel if everyone can tolerate me a little bit longer. We're gonna go for maybe 70 to 80 minutes. And I know that's a bit long, but this is an important subject and there's some heavy things we need to get to. And I appreciate everyone's patience and attention. This is a hybrid session. Questions will be gathered from the face-to-face audience as well as the Zoom audience. There's a reception to follow, so please stay here and we'll make sure that you're fed as a reward. Your parking will be validated. Anusha, can you just raise your hand? She's in the back, she will help you out. And also, if you need CLE credit, also see Anusha. I think now, with that said, I will transition. I think if we turn our lapels on, friends.
Earlier, just wanted to make sure everyone's hydrated for a very long conversation. still seen and heard. Camera about it, which was fantastic. So each participant will have 5 minutes to answer each question, 4 rounds of questions. I may, musical chairs, please pardon me. This is definitely madness. So, the first question concerns campus free speech. University and college campuses have long been hailed as incubators of free speech, fostering critical thinking in the next generation and promoting justice in a healthy democracy. At times of national and global crisis, so the Vietnam War, wars, presidential elections, the aftermath of George Floyd, Taylor murders, the COVID pandemic, and even now the latest conflict in the Middle East. During these times, campus free speech has come fire. The most dramatic confrontation between the American political establishment and higher education has come in the wake of the December 5th, 2023 congressional hearings. The president of MIT, and now former president of Harvard, and former president of the University of Pennsylvania, were closely questioned for how their universities would handle anti-Semitic speech on campus. The American Civil Liberties Union, ACLU, states, maybe read part of it, I wish I could help it, I didn't think of the part. The First Amendment to the Constitution protects speech, no matter how offensive.
Restrictions on speech by public colleges and universities amount to government censorship in violation of the Constitution. Such restrictions deprive students of their right to invite speech they wish to hear, debate speech with which they disagree, and protest speech they find bigoted or offensive. An open society depends on liberal education, and the whole enterprise of liberal education is founded upon the principle of free speech, end quote. And it adds, quote, the First Amendment does not protect behavior on campus that crosses the line into targeted harassment or threats, or that creates a pervasively hostile environment for vulnerable students. But merely offensive or bigoted speech does not rise to that level. And determining when conduct crosses that line is a legal question that requires examination on a case-by-case basis. End quote again. So the question, again, the question is multi-layered, and I'll begin asking it now. So first and foremost, I recognize that I'm not a constitutional lawyer. I'm actually not, I'm the only one here who's not a lawyer. I'm an interloper. But the ACLU's description of the First Amendment on campus, on campus speech, seems to align with what the 3 university presidents were saying in their testimony, right? So the first question is, do you agree? Noting that those universities are not public institutions, the presidents were criticized for their responses. So if you were one of those university presidents, how would you have answered differently, especially about the question on genocide? Are there any limits on campus free speech for faculty, students, or administrators? How do faculty, students, and administrators exercise their First Amendment right on campus? And finally, do administrators or regulators have the right to limit students' speech? So that was a lot. And I would like to begin, actually, Professor Whedon, would you give us the honor of answering?
Sure. And thank you for inviting me. As a university president, I would have answered the question on genocide by quoting the authors of my constitutional law textbook, Feldman and Sullivan. They say the First Amendment assertion that Congress should make no law abridging the freedom of speech as written is simple but unqualified. Feldman and Sullivan correctly assert there's been a broad consensus that not all expression or expressions is included within the freedom of speech. In my view, speech which encourages or solicits others to commit genocide or murder is speech that is not protected by the First Amendment. Feldman and Sullivan have declared that it should be obvious that many speech acts receive no First Amendment protection, such as bribery, perjury, and antitrust conspiracies, solicitation to murder, are not considered as protected speech. Since genocide may be defined as deliberate killing of a large number of people from a particular nation or ethnic group with the aim of destroying that nation or group, as president, I would take the position that the advocacy of genocide is not protected speech under the First Amendment Free Speech Clause. Yes, there are limits on campus free speech of faculty, students, or administrators. On June 27, 2023, the U.S. Supreme Court decided the Kahneman versus Colorado case. In Kahneman, the defendant was convicted in a Colorado district court of stalking and harassment. In his Kahneman opinion, the court said, from 1791 to the present, the First Amendment has permitted restrictions upon the content of speech. The Supreme Court held in 1942 that the 14th Amendment does not protect, as I said earlier, fighting words. But this is an extremely limited exception. It applies only to intimidating speech directed at a specific individual in a face-to-face confrontation that is likely to provoke a violent reaction. For example, according to the ACLU, under the fighting words unprotected speech doctrine, quote, if a white student confronts a student of color on campus and starts shouting racial slurs in a one-on-one confrontation, that student may be subject to discipline. The fighting words unprotected speech doctrine does not apply to speakers addressing a large crowd on campus, no matter how much discomfort, offense, or emotional pain their speech may cause. The ACLU says in the First Amendment Free Speech Clause does not protect the one of nonverbal symbols that directly threaten an individual, such as hanging a noose over their dorm room or office door. The Supreme Court in Brandenburg versus Ohio said the state may prohibit incitement speech. Incitement involves statements that are directed at producing imminent lawless action and is likely to do so. Under the Supreme Court's reasoning in Brandenburg versus Ohio, the government can punish inflammatory speech that intentionally and effectively provokes a crowd to immediately carry out violence and other unlawful actions. According to the ACLU, the First Amendment's protections provided by the court in Brandenburg reflects two fundamental important values. First, political advocacy, rhetoric meant to inspire action against unjust laws or policy is essential to democracy. Second, people should be held accountable for their own conduct, regardless of what someone else may have said. To protect these values, the First Amendment allows lots of breathing room for the messy, even bigoted speech that is part and parcel of American politics. It's the price we pay to keep the bullhorn in the hands of political activists. And faculty, students, or administrators who want to exercise their First Amendment rights on campus may find it very helpful and useful to study the advice and guidelines published in the ACLU Speech on Campus document. The ACLU Speech on Campus document asserts that the First Amendment to the Constitution protects speech, as was said earlier, no matter how offensive its content. Restrictions on speech by public colleges and universities amount to governmental censorship in violation of the Constitution. When we grant the power to suppress controversial ideas, we're all subject to censorship by the state. According to the ACLU, the right to free speech is not just about law, it's also a vital part of our civic education. Teaching constitutional values and the value of a free expression should be nothing less than a core mission of any college or university. As a general reminder, the ACLU says Restricting such speech may be attractive to the college administration as a quick fix to address campus tensions, but real social change comes from hard work. To address the underlying causes of inequality and bigotry, not from, super clean discourse. The ACLU believes that instead of symbolic gestures to silence ugly viewpoints, colleges and universities have to step up their efforts to recruit diverse faculty, students, and administrators, increase resources for students, counseling, and raise awareness about bigotry or prejudice.
Thank you so much, Professor Whedon, for a very thorough and well laid out answer. We'll move directly to Professor Peel.
So thank you, Professor Al-Badawi, and to the Dean, to the Boniucs. I appreciate the invitation, and I'm glad to be here. I think, for me at least, the place to start here is the very basic idea which the Dean already reviewed. No problem. I think the place to begin for me is the very basic point that the First Amendment is a legal rule. It applies to the government, and it applies to government regulation of speech. It forbids the government, state governments, federal governments, local governments, as well as their agencies, instrumentalities, including public universities, from regulating protected speech, except where such restrictions are strictly necessary to achieve very compelling government interests. It does not apply to private speech. Private speech can be regulated by private entities, and that's perfectly fine. That doesn't offend the First Amendment. I think it's also important to articulate the point that societies are made up of many different overlapping systems of social ordering. Law is one of those systems of social ordering. There are many others. Religion is another system of social ordering. Politics is another system of social ordering. Culture, politeness, etiquette, economics. There are many, many systems by which we order our societies and create structure and effective, efficient, predictable, smooth ways of doing things. Law is one of those, and it's an important one, but it has its limits. We should be careful when we uncritically assume that a legal standard should automatically be applied to other kinds of social ordering contexts. We wouldn't expect a parent to apply all the requirements of procedural due process before punishing their child for not doing their homework. We don't expect a warrant to be obtained before checking your teenager's pockets for cigarettes. You do it, and in fact, our own constitutional system recognizes that you can't apply constitutional norms to those situations. Parents have more or less carte blanche to raise their kids the way they want to, and they have a right to do so. And we don't want the standards we use to regulate and restrict government to apply to private situations. All that is to say that we should be careful and thoughtful before assuming that just because something is a First Amendment value or principle, it should necessarily be a private speech or a private speech context value or principle. And even in the public context, we know, and the Supreme Court has spoken on this on many occasions, that even in the public education context, free speech is not limitless. Public education is public and also education. The ACLU's definition that Professor Al-Badawi mentioned earlier is an important one, but I think the ACLU is saying a little bit too much or claiming a little bit too much when it talks about liberal education, or the whole enterprise of liberal education is founded on the principle of free speech. Liberalism certainly is, but liberal education is not only liberal, it's also education. Even in public education contexts, public schools, public universities can indeed regulate speech in order to facilitate necessary learning environments. students can be punished for disruptive outbursts in the middle of a professor's lecture. And that's perfectly fine. They can be a student could be penalized, I imagine, although counsel would be able to say much better than I could, peppering a professor in the middle of a lecture with irrelevant questions as opposed to relevant questions, which might be a content-based sanction on their speech. So even in public universities, I think it seems acceptable and that within the confines of the actual First Amendment, we can regulate speech in order to facilitate the necessary conditions of what it takes to create a good learning environment, an effective learning environment. All the more so, I think, that's true in the context of private education, where the university, a private university, is not bound by the First Amendment in any strict sense. And I think it's sort of silly for us to, again, uncritically assume that just because we like the First Amendment and we like our Constitution, and I do, that means that we should apply the same values in every aspect of our lives. We don't do that. And in a private education context, I think first and foremost, the obligation of a university is to provide a conducive, effective learning environment for their students. As the ACLU definition tells us, and I think it's a good one, that requires liberalism. You can't get a good education if you're not exposed to many different points of view, and you're not forced to contend with all the points of view that make you squirm and make you uncomfortable and force you to figure out what you really think and how to counter the things that you instinctively think are wrong. You have to be exposed to those things, and that's part of what a liberal education takes. And at the same time, education, I'm not an education expert, but from what little I know of education and what we increasingly find in studies point in this direction more and more, a good, effective education requires a certain sense on the part of students of safety, comfort, security, a certain kind of emotional, affective environment, if you will, to facilitate student learning. And I think private universities certainly are required to provide that, public universities as well. Public universities may be more limited in how they can provide that because they are ultimately bound by the First Amendment, and that could impose more restriction on what they can do to regulate speech to create that effective education environment. But private universities have carte blanche to figure out what it takes to make that kind of environment and to implement, pass, adopt speech regulations on campus to facilitate that. What those regulations should be, I don't know. Thankfully, that's not my job. I'm not an education expert and I'm not a university administrator, and I don't want to be one. But whatever.
Not now, anyway.
Not now, anyway, yes.
Maybe 5 or 10 years from now.
Tenure first, and then we'll worry about the next. But I think this is something that is appropriate for experts to discuss and figure out in that kind of context. But we should be guided here, I think, importantly, not by First Amendment principles. This isn't, again, outside of a public university, but in a private university, certainly, we shouldn't assume that we should be guided by First Amendment principles. And with respect specifically to the university presidents that Professor Al-Badawi asked about, I think it's a little bit disingenuous for university presidents to take shelter in the First Amendment. That's a little bit of a cop-out. If you're the president of a public university, you can say my hands are tied. If you're the president of a private university, I think you have to do the hard work of saying, what does it actually take to create an affective learning environment for all of our students? A confrontational environment, an environment where you're challenged, but nevertheless an environment where you're secure and safe enough to learn. And you can't hide behind the First Amendment when you don't want to do that. So that's what I would say.
Thank you so much, Professor Peel, especially for identifying for us the difference between private and public and just how complicated this is. I must say, I'm glad I'm not an attorney because I couldn't do it. Right? This is complicated territory. We will deliberately skip the university administrator till the end. Now, would you like to take a stab at it?
What was the question?
I think the question, as best as I recall, was whether I agree with that ACLU statement about how the concept of free speech applies. And my short answer is no. And the longer explanation of why my answer is no has a couple of different components. And I think that these components are going to be relevant to all of the questions that we discuss this evening. And I'm able to say that because Professor Al-Badawi distributed the questions. He also gave us a time limit, so on how long our answers were supposed to be, and so I'll try to adhere to it. The first thing that I want to say is, and I say this with some reluctance, but the title of this program has the phrase hate speech in it, and nobody knows what that phrase means. There's not any legal decision that defines what hate speech means. If you read philosophy or legal analysis of the concept of hate speech, even those who address it in a scholarly context can't settle on a definition. I have no idea what it means. And so on the question of where do I come out on hate speech, I have to say, well, what do you mean by hate speech? And the likelihood is that we're never going to be able to answer that question in a rigorous enough way that it's even possible to answer the question. If it were possible to answer the question, I would say that there's some hate speech that's good. I think that there's some things that are hateful, and the speech that is directed towards those things ought to be hateful. I think, for example, Nazism is bad, and so speech directed towards Nazism should express hatred of Nazi ideology. So even if we knew what it meant, I would say that there are some things that count as hate speech that I don't think ought to be suppressed. So one of the themes that I would like to stake out is that I think we have to be very careful when we're talking about these ideas, because we don't exactly even know how to define the terms in the ideas. The second thing I want to say is this. I'm a law professor. Everybody up here, with the exception of our moderator, and this is obviously a gold star for him, is either a law professor or a graduate of a law school. And I think, consistent with what I heard Professor Pill saying, I think that law can lead us awry in how we analyze these questions. Because what law likes to do is create categories and put something in a category and then have a different set of principles that applies to each category, and just apply the principle in a wooden fashion to the category and spit out an answer. And I don't think that that's how moral human beings actually approach these questions. There are a lot of things to dislike about Thomas Jefferson, but one of the things to very much like about Thomas Jefferson is that he had, and Jefferson is I think, if he's not the smartest person ever to have occupied the Oval Office, he's certainly in the top three. There was somebody who, a scholar of the presidency, Gary Wills, once said when there was a collection of Nobel laureates at the White House that it was the greatest collection of intellectual horsepower at the White House since Jefferson dined alone. So Jefferson was an enormous intellect, and there are a lot of things to not forgive him for, but one of the things that he was very committed to was this idea that human beings have a very strong moral instinct about what is right and what is wrong, and that instinct is typically superior to the answer that one gets from a philosopher or a scholar on a moral question. Jefferson has a famous example where he says that when trusting someone with the answer to a moral question, he would rely more on a farmer than he would on a professor. And I think what Jefferson's intuition was that we have these almost reflexive ideas about what is right and what is wrong, what is good speech, what is bad speech, what should the campus permit, what should it not permit. And that when we start breaking down all of these utterances and placing them in different boxes, as legal doctrine wants to do, and then placing principles on top of those, we spit out answers that can often diverge from our moral intuitions. And I think that we should trust our moral intuitions. And I think the great failure of the presidents at the congressional hearing was that they were trying to parse the answer to a question that we all have a very, I shouldn't say all, that most of us, I think, have a very strong moral reaction to. And so if the question is, if there's somebody calling for genocide, is that protected speech? The answer is, I don't need to consult a First Amendment book. I don't need to consult a Supreme Court case. I don't need to look at a law book. My moral intuition is that when one group of people is calling for the extermination of another, it's not protected speech. And I don't have to cite any cases, and I don't have to articulate grand principles. I can simply say that there's some speech that's acceptable and there's some speech that's not. And on a broad swath of speech, reasonable people are going to disagree. But on narrow categories of speech, some of them very far left, some of them very far right, all reasonable people are going to agree that the speech is bad.
Okay. Thank you so much. Okay. I'm very engrossed and immersed in the answers, so thank you so much, Professor Dow. General Counsel Cornell.
Wow. I am not a law professor. I am kind of like a farmer. I like that analogy.
Really, Donna.
That is. Actually, let me start with one of the questions in the middle. Would I have answered the question the same way those presidents did? And I will tell you, I reflected on this a lot because I was going to have to talk to the chancellor. I was going to have to talk to my team. I'm going to have to talk to the administrators. What would we have done, and how would we have reacted, and what would have happened? There is no doubt in my mind that they answered the questions wrong. They did not do what any good lawyer would do, especially one like me who was trained as a litigator. You prepare for a trial. You lay out everything. You know what's going to happen. You have all your notes. You've read all the depositions 10 times. You think you know exactly what's going to happen. And the opening statement of the plaintiff, you're the defendant, starts, and then everything changes. And you have to totally change exactly what you were going to, had this beautiful plan to do. In this case, if you look at the testimony and you see how it started, first you knew the tone, because one of the first things the Congresswoman said was, I'm going to give you an opportunity to atone for the decisions that had been made by these university presidents or by the administrators. So you know the tone to begin with. But the first thing they do is show a clip of 3 demonstrations at MIT, at Harvard, and at Penn. And if you go back and look at that, and I encourage you to do so, I'm telling you, if you were walking, first of all, if you were a 19-year-old student, let's just put yourself in those shoes. Would you have been terrified that something terrible could be happening to you as you walk through that gauntlet of protesters? I would have been horrified on our campus if that was happening. And we obviously have a real problem. And those presidents should have been bold enough to get out of their trial preparation mode and said, absolutely, that was not okay. It was horrifying. And those students would have been scared, without any doubt in my mind. I was scared. Watching that video clip again, I would have been scared at 62, knowing all the things that I know. I mean, it was incredibly, incredibly disappointing that they just sat there and listened to, frankly, these high-priced lawyers making $1,000+ an hour give them ridiculous advice that was looking at case law and having experience of writing briefs to the Supreme Court, and somehow they're going to know practically how to handle that problem. We deal with these problems every day. not every day, thank God, but on a regular basis. And so I will tell you, one of the first things I did was I go back and I look at, because we are a public institution, and yes, we are bound by the First Amendment. Do we go back and look at the First Amendment? Yes. The cases interpreting it. We go back and looked at our policy. I pulled my team together. One of the members is here. Like, okay, guys, this was bad. Do we have it right? Because you never know how good a policy is until you have to apply it. And these presidents were being asked to apply their policy. They probably didn't even know what their policy said, but I'm telling you, that's the first place I would go. I go to my policy and I'm like, is it against our policy? And so this is what we say about hate speech. Is hate speech prohibited? And it kind of talks around what the ACLU said, but I really believe their statement here is more aspirational, in part not really a recitation of what the law really is. Hate speech and I agree, there is no real definition of hate speech, but we have to come up with something. Hate speech or hateful speech, which is the way I like to explain it when I talk to especially students, is generally defined as speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or other similar ground. Although some would argue, and of course there are other things, but I'm trying to tie it back to our policies. Although some would argue or believe hate speech is not protected, generally that is not the case. Though offensive, it may not necessarily fall under one of the exceptions to the First Amendment listed in answer 4 above. And I'm reading from, we've issued not just our policy, we have a freedom of expression website, we have frequently asked questions, because this stuff has been in my world the entire time I've been here. In fact, on many occasions, the U.S. Supreme Court has explicitly held that prohibitions or punishments for hateful speech violate the First Amendment. And a lot of those cases say that. In fact, most of the cases strike down the different attempts to limit speech. Most of the Supreme Court cases that I've looked at, which I did look at a few, they strike down those attempts. But the Supreme Court has also said that speech that directly incites imminent criminal activity or consists of specific threats of violence targeted against a person or group is not protected under the First Amendment. So targeted against a particular group. And then, I pulled the Dear Colleague letter, which the Department of Education issued in November, a month after the Hamas attack. And the Department of Education helps me out a little bit and says, harassing conduct can be verbal or physical and need not be directed at a particular individual. So even though nobody knows who that student is walking through this gauntlet of protesters, it doesn't really matter. It doesn't have to be directed at those particular students. But the truth of the matter is, we've got a problem when our students don't feel safe. And that is something a public school, a private school, any school has got to take action about.
Thank you so much, General Counsel Cornell, especially because protests, we were talking earlier, I mean, in some sense, it's kind of a hallmark of going to university. Young people like to protest various grievances. And we appreciate, of course, the role that you have at the university, at the front line. Okay, we'll continue to move on. I'm going to hand it over to Professor Berman, and we're going to try and do 5 minutes apiece, right? So.
Okay, so our second question is about hate speech, however one might choose to define that. And hate crime. And so there are multiple studies linking or documenting the connection between hate speech and hate crimes. And over the past sort of decade and more in the United States, we've seen numerous hate crimes carried out against racial and ethnic minorities, particularly through the mechanism of mass shootings. So you can think about the targets of Asian American women in Atlanta in 2021. You can think of the targeting of Hispanics in El Paso in 2019, the shooting at the Tree of Life Synagogue in 2018, the Charleston church shooting. So all of these events often are fueled, at least in part, by online extremist language and extreme radicalization online. And the US is largely unique in this sense. The problem that we have with mass shootings directed against particular racial and ethnic minorities. So here's the question. The first question, how do you define hate speech? So that is, maybe we'll skip that one. But do you believe that there's a connection between hate speech and hate crimes? And why is it that the laws that we currently have and law enforcement mechanisms that we currently have aren't more effective in preventing these sorts of events? Is the problem social media? Is the problem access to weapons? Is the problem the First Amendment is too protective of hateful speech? Why aren't we better at stopping these events? So are we going in the same order? Or you want
Sure,
to mix it up?
the same order.
Okay.
Oh,
That's
I take great comfort in the attempt to define hate speech. Okay, and let me bring your attention to this point. And I think it's a functional definition. I think the definition of hate speech used at the University of Wisconsin-Milwaukee is appropriate. Here I have to refer to as UWM. UWM believes hate speech may be offensive and hurtful. However, it is generally protected by the First Amendment. UWM says, one common definition of hate speech is any form of expression through which speakers intend to vilify, humiliate, or incite hatred against a group or a class of persons on the basis of race, religion, skin color, sexual identity, gender identity, ethnicity, disability, or national origin. According to UWM, courts have held that restrictions on hate speech would conflict with the First Amendment's protection of freedom of expression. Since public universities are bound by the First Amendment, public universities must adhere to the court's rulings. UWM recognized that any restriction on hate speech does not relieve universities of their obligation to create a safe, inclusive learning environment for all members of the campus community. While recognizing the tension between hate speech and free speech and student safety, the UWM takes the position courts in the United States have found that expression generally cannot be punished based on content or viewpoint. Therefore, although hate speech alone receives constitutional protection, any expression that constitutes a true threat, incitement, or imminent lawless action, discriminatory harassment, or defamation can be punished by UWM for those reasons. Now, I can't believe I'm here defending the ACLU, but I am. The ACLU contends restrictions on speech are not an effective and appropriate way to fight against prejudice and intolerance because of their unintended consequences. The ACLU says, historically, restrictions on speech have proven at best ineffective and at worst counterproductive in the fight against bigotry. Although drafted with the best intentions, These restrictions are often interpreted and enforced to oppose social change. Why? Because they place the power to decide whether the speech is offensive and should be restrained with authority figures, the government or a college administration, rather than those seeking to question or dismantle existing power structures. For example, under a speech code in effect at the University of Michigan for 18 months, there were 20 cases in which white students charged black students with offensive speech. One of the cases resulted in the punishment of a black student for using the term white trash in conversation with a white student. The code was struck down as unconstitutional in 1989. Now, according to author F. Sellers, in his article entitled Defining Hate Speech, says, although the United States does not make hate speech per se illegal under any definition, the Supreme Court's decision, Berharnis versus Illinois, which was mentioned earlier, represents a time when the United States Supreme Court held that a state law prohibiting hate speech targeting a racial or religious group did not violate the First Amendment free speech clause. Yes, I believe hate speech turns into crime for the reasons articulated by the Supreme Court in its Berharnis decision in 1952. Berharnis was convicted in the city of Chicago of violating the Illinois Criminal Code. He was fined a couple $100. The Supreme Court rejected Berharnis' challenge to Illinois' code as a violation of the First Amendment freedom of speech. Berharnis was convicted under the Illinois statute because he did unlawfully exhibit in a public place publications portraying the depravity, criminality, or lack of virtue of black citizens. And black citizens of Illinois were, as a result of the publication, were said to be exposed to contempt. Berharnis requested the mayor and city council of Chicago to halt further encroachment, harassment, and invasion of white people, their property, neighborhoods, and persons by black people. The leaflet called for 1 million self-respecting white people in Chicago to unite, with the statement added that if persuasion and the need to prevent the white race from becoming mongrelized by blacks will not unite us, then the aggressions, rapes, robberies, knives, guns, and marijuana by the blacks will. Now, in the Berharnis case, and the Supreme Court made the following observation. It said, if an utterance directed at an individual may be object of criminal sanctions, we cannot deny a state the power to punish the same utterances directed at a defined group when that restriction on speech is related to the peace and well-being of the state. The court said Illinois did not have to look beyond her own borders to conclude that willful purveyors of falsehood concerning racial and religious groups promote strife, obstruct the manifold adjustment required for a free, ordered life in a metropolitan community. And the court does a history walk. It says, from the murder of the abolitionist Lovejoy in 1837 in Cicero, Illinois, the rise of 1951, Illinois has been the scene of high tensions between races, often flaring into violence and destruction. The speech restriction in Berharnis did not violate the First Amendment free speech clause because the Illinois legislature could reasonably conclude, according to the court, many of these riots in a significant way were caused by the willful purveyors of falsehoods concerning a racial or religious group. There are limits to the exercise of the liberty of speech and of the press, the court said. The danger in these times from the coercive activities of those who, in the delusion of racial or religious conceit, would incite violence and breaches of the peace in order to deprive others of their equal rights to exercise their liberty is emphasized by events familiar to us all. Under the reason of Berharnis, the state may appropriately punish speech that target groups which is reasonably likely to incite group, racial, or religious violence without violating the free speech clause. Caveat though, Bahamas has not been overruled technically by the court, but commentators contend that the court has not really followed Bahamas in any other subsequent cases. First, I think it is necessary and proper to distinguish hate crime and hate speech. Lisa Ho, in a comment published in the Santa Clara Law Review, makes the following distinction between discriminatory hate crime and discriminatory hate speech. This comment distinguishes between hate crime and hate speech. For purposes of this comment, hate crime or hate violence refers to any act of intimidation, harassment, physical force, or threat of physical force directed against any person, his or her family, or his or her property, or advocate, motivated, either in whole or in part by hostility to the person's real or perceived ethnic background, national origin, religious, sex, age, disability, or sexual orientation with the intention of causing fear or intimidation. In her law review publication, Ho declares, hate violence is a growing problem. It must be controlled and reduced by passing constitutionally appropriate legislation. Legislation needs to acknowledge that an individual's expressive freedom is protected by the First Amendment. In short, legislators must limit their substantive criminal hate crime regulations to punish only discriminatory violent conduct, not purely offensive speech. The First Amendment protects an individual's freedom to believe whatever he or she wants, and even to express messages in the furtherance of those beliefs. However, if such person intentionally inflicts violent conduct on an identifiable victim because of bigotry, the government must have the means to substantively prescribe such behavior. In other words, although every individual in society is free to hold beliefs of his or her choosing, including bigotry and bias, constitutionally permissible substantive penal hate crimes would send a message that outrageous hate violence and victimization will not be tolerated. Ho contends in the final analysis that community members must educate, build awareness, and gain acceptance of each other to reduce and ultimately eliminate bigotry and intolerance. Until then, carefully drafted substantive penal hate crime legislation is a necessary means to protect every member of society from discriminatory violence.
Can we leave it at that?
Yes.
Okay. Thank you. That was plenty.
I think I got my good 5 minutes in. Come on. Thank you for your generosity.
So I'm going to echo Professor Dow and point out that hate speech, hate crimes, these are not natural categories with natural definitions. These are terms that we use. These are moral terms, ethical terms, social terms, even to the extent that we might use them legally. They're constructs, right? These are terms that we use to identify particular kinds of expression or particular kinds of conduct as specially reprehensible, as deserving of extra special condemnation because of the motives, the ideas that are motivating the conduct or the ideas behind a particular, the speech. As social phenomenon that defy natural definitions or objective definitions, it's no surprise, of course, that definitions of hate crimes or hate speech differ widely, and even to the extent that we speak of legal definitions for these terms. They differ widely, and they're often based on culture and history and so on, right? In the United States, we have a very different conception of freedom of speech and hate speech than we find in the UK, than we find in Germany, for example, than we find in the state of Israel, in many Muslim majority countries. Culture, history, religion, a variety of other social considerations, contingencies, give us very different working definitions of these terms. Now, I think hate crime is a useful legal category. I am uncomfortable, I admit, with the idea that we should penalize otherwise criminal conduct for the motives that are behind that conduct. The motives behind the conduct are a form of self-construction, self-expression. If it's already illegal to do a certain thing, I'm somewhat uncomfortable with saying it's more illegal because of why you did that thing. Nevertheless, I think it's also naive for us to think that criminal conduct that's motivated by racial, ethnic, religious, gender, sex-based animosity, and which communicates this hatred to victims of such crimes, isn't a unique social ill that has broader societal consequences beyond the criminal act itself. And therefore, maybe it's a useful legal category and something that law can and should address given its social consequences. I'm much, much, much less comfortable with speaking about hate speech as a legally relevant category. And as other panelists have pointed out, at least in the United States, we don't. We don't speak of hate speech as a legally relevant category. In First Amendment jurisprudence, we don't recognize hate speech alone as a legal concept that permits regulation by the government to prohibit or punish different forms of expression. There are narrow forms of speech like obscenity and fighting words that fall outside of the First Amendment. And there are categories of expression that don't really further the goals behind the First Amendment, or which pose such serious and imminent risks to becoming problematic and criminal action, such that our society deems them necessarily subject to regulation. But hate speech is not those things. Hate speech is offensive, it's reprehensible, it's hurtful, it's othering, it's shocking, it's indecent, and that's exactly the sort of stuff that the First Amendment is there to protect. And I think that that's the right result. By definition, hate speech is a social phenomenon. And what constitutes hate speech evolves along with society's changing cultural and social attitudes, values, mores, etc. We label hate speech as hateful because it expresses hatred towards others. But really, we designate speech as hateful when we really, really hate the attitudes and the ideas that it's expressing and communicating. And we don't label as hate speech, hateful speech that hates the things we hate. We hate racism, we hate bigotry towards ethnic minorities, we hate homophobia, anti-Semitism, Islamophobia, and so we label such expressions as hate speech. But of course, this wasn't always true. It's not very long ago that many of these ideas were acceptable in polite society and were not considered hateful speech. When it comes to fundamental values like constitutional protections for speech, I think it's important to avoid choosing what we will or will not protect on the basis of shifting notions of what is socially tolerable, and hate speech is just such a category. Now, I think it's undeniable, although I'm not a sociologist and I'm not a statistician, I think it's undeniable that there's a connection between hate speech and hate crime. It's no surprise that when not everybody says what they think, not everybody acts on what they say, but in a social environment in which expressions of hate are routine and normalized, we have an environment where previously unthinkable acts become conceivable, possible, and then done. Nevertheless, hate speech, I think, in our system at least, is not regulable, is not a coherent or useful legal category, and this does in fact mean that we have a problem. If hate speech correlates to hate crime, we're at a disadvantage in preventing hate crime. We can't address one of the things that drives hate crime, or at least address it legally. But again, as I said before, I don't think the solutions are always legal. Not every problem is best addressed by a legal response, and here I think there's very much that can and should be done through all of those other mechanisms of social ordering to directly, to deal with hate speech, to nip it in the bud, to make it so socially unacceptable as to not be, it's the quiet part that no one's willing to say out loud. And without regulating it, I think that that's much better. That's a much better way of trying to deal with the problem.
I'm going to start by agreeing with something that Professor Pill said, and that is that there is often a connection between speech and action. If we didn't think that our speaking could cause people to act, to change their behavior, why would we talk? We wouldn't talk. Most human conversation, or at least a great deal of human conversation, is aimed at trying to persuade people to behave in a certain way. Go vote in November. That's speech, and it has as its objective getting you to vote in November. And so I think that it simply goes without saying that the point of much of our speech is to cause action. That said, we have this basic idea in law, which is that we punish the person who acted, not the person whose speech might have caused the action. I might read a book. I might read a book written by somebody who inspired Hitler and be inspired to go kill a bunch of Jews at a synagogue. We can't punish the author of the book, even if he were still alive, because I read the book and I acted on the basis of it, and we typically punish the actor. And I think the reason that we do that is because the chain of causality between the speech and the action is typically too large to try to to try to punish somebody who is involved in that chain of causation. You know, we have a hurricane and we say, oh, well, the world is complex and that was set off by the flapping of a butterfly's wings, you know, some time ago. But the chain of causality is so long that it's ridiculous to say that the butterfly caused the hurricane. So I think we do the same thing when it comes to speech and conduct. We say the chain of causation is just too long. Why did somebody kill somebody? Well, the reason that somebody killed something is because the person exists. And why does the person exist? Because the person's parents fell in love. And why did those parents exist? Oh, well, because the grandparents existed. And so we can therefore draw a direct connection between the grandparents and the shooting. It's preposterous. And it's because the causal chain is so long. So in law, we typically punish the action, not anything that happens along the line of causation. That said, there is some speech that is very close to the action. January 6th would not have happened but for a bunch of Twitter accounts. And so that chain of causation is much shorter. I'm not suggesting that we should therefore punish the speech in those circumstances. I'm simply saying that sometimes the causation chain is shorter and we can have a greater degree of confidence in the connection between the speech and the conduct. So my first point is that speech causes conduct, but our legal system and our moral system punishes the conduct. The second thing that I want to say is that from the point of view of attributing culpability or moral badness to the conduct, I think whether it reflects hate or something else is really quite irrelevant. You know, there were 2 shootings in Florida in very close proximity to one another, one at a high school and one at a gay nightclub. The one at the gay nightclub could be characterized as a hate crime because it was directed against gay people. The one at the high school, can't really characterize it as a hate crime. Was one worse than the other? 2 shootings in Texas. One at a store in West Texas carried out by someone who abhorred immigrants, and another one at a high school in Santa Fe, just down the road from here. You know, one worse than the other. Has there been any mass shooting in recent years that is worse than Sandy Hook, where children were killed? You know, and so without taking back at all what I suggested a moment ago, which is that I think that there is very often a connection between speech and action. I think the reason that we punish the actions is because whether the action was carried out by somebody who was hateful toward a particular racial or ethnic or political or sexually oriented group is finally not relevant to the moral wrongness of what that person did. And so this is yet another reason that I'm not sure that the category is really very helpful. The category of hate speech, hate action. The action that we punish typically because how bad it is not a function of what the motivation of the bad guy was. And I have 1 minute left, and so I just want to say one last thing. I want to strongly endorse the point that Donna Cornell made a moment ago where she was talking about the function of the university and the role that certain speech and conduct can have on the university campus. The function of the university is learning. The modern university in the United States has its roots in German universities from the mid-19th century, and the goal was not trade school, which is why it's so terrible that you have places like University of West Virginia eliminating all of the social sciences and humanities. They weren't trade schools. They're schools where the idea is that people with certain viewpoints are going to have those viewpoints tested by people who have very different viewpoints. And often that testing can be very hard-headed. It can approach violent dialogue. But that's the function of the university, for people to be able to defend their positions, for people to be able to absorb criticism of their positions, to learn from people who disagree with them. And so while I think that Donna is absolutely right that there are circumstances where the speech can be intimidating, I think we also have to bear in mind that a central function of the university, both public and private, is to teach people what it is to have their viewpoints challenged and teach people what it means to defend those viewpoints against those who disagree with them. Now I'm definitely at my limit.
Okay, great. I'll try not to take my full 5 minutes. How's that?
Please take your time.
We don't punish, the criminal justice system doesn't go after people for their thoughts. It goes after people for what they do and what they've done. It just doesn't work like that. So this concept, and we can talk theoretically how hate speech doesn't have a real definition. And I've even that language in our FAQs trying to go down that path. But let me be 100% clear. Our students totally expect us to respond to what they perceive as hate speech. And yes, it's part of the educational process. But what do you do as a university administrator when you have students who are intimidated by what another student puts on their dorm room door? Does the university just say, well, everybody's entitled to their own opinion and that's free speech? It's more complicated than that. It absolutely is part of the learning opportunity for our students to understand the different viewpoints and to some extent tolerance. I have a lot of kids. I have 12 grandchildren. I know a lot about the way they think in this day and age. They really expect safe spaces. I hear that phrase all the time. They don't want any hate or what they perceive to be hate or hateful comments around them. That's protected speech. But our students still expect safeness, secure, and we have, as a university, have to figure out how to respond to that in a way that obviously doesn't punish students for their free speech, but still deals with the issues that our students who are offended by something have to go through the next day. You know, we have had situations where a faculty member just puts up, I use the real life example, on their Blackboard, video Blackboard, but we call it Blackboard. There's going to be a teach-in on Palestine. And I've got a student who feels so triggered by, this is the language of our kids today, triggered by that she will never be able to go back to that class based on her life experience, what she lived through. Doesn't affect anybody else in the class, but that one student is terribly, terribly impacted by it. And we as a university absolutely have an obligation to do something to help that student, even when it is protected speech.
Wow.
Complicated.
I'm glad it's not my job. Okay, so moving on to our next topic is hate speech and technology. And as many people in the room may know, both Texas and Florida passed legislation recently barring social media companies from blocking or removing content based on the subject or the viewpoint expressed in the content, because they were concerned that social media companies were disproportionately removing conservative perspectives. And this case, the case is now in the Supreme Court, and the Supreme Court has granted cert on two questions. So the first is whether state provisions that regulate the company's ability to control content on their platforms violates the First Amendment. And second, whether provisions that require tech companies to explain their decision to regulate content violate the First Amendment. So we have legislatures who recognize the power of social media and the sort of pervasiveness of it in people's lives, and yet all indications are that hate speech is taking off on social media. However one defines that, speech that people will find offensive and hateful. So the question is, if you bar social media companies from being able to block content on users' viewpoints, what does that do to their ability to regulate or restrict offensive speech, hate speech, however they want to define it? Second question is, should they be regulating hate speech on their platform? Should hate speech be regulated on social media platforms at all? And if so, who should be doing that regulating? Should it be the companies themselves? Should it be imposed by the government? And then third, given how difficult the content moderation project seems to have been for these companies, are there mechanisms other than content regulation to counter problematic speech on social media platforms, whether that's defamation suits or advertiser boycotts or counter speech on the platforms? If regulation's not the answer, is there some other way of accomplishing that? Professor, what do you say?
Okay, on December 8, 2023, an article written by Thomas A. Berry, published by the Cato Institute. Berry makes the argument that the Texas and Florida social media law violates the First Amendment. 3 years ago, Texas passed a law declaring that large social media services are common carriers subject to onerous regulations dictating what speech they must disseminate. The law prohibits these services from removing, demonetizing, or blocking a user or a piece of content based on the viewpoint expressed. Services found to violate this requirement face liability for each piece of content they remove. The law has, as was said, the law was soon challenged by NetChoice and CCIA, two internet trade associations whose members operate a variety of websites covered by the law. Although a federal district court held that this law violated the First Amendment, a panel of the Court of Appeals for the Fifth Circuit reversed that decision by a 2-to-1 vote. The panel held that the law does not inflict a First Amendment injury because the websites are free to say whatever they want to, distance themselves from the speech they host, and thus would not be falsely identified as endorsing the speech they are forced to disseminate. Florida passed a similar law around the same time as Texas, which also was challenged by NetChoice and CCIA. In that case, the Court of Appeals for the 11th Circuit struck down key provisions of the law as violating the First Amendment rights of the websiters. The Supreme Court has granted review of both cases, and now Cato has filed a joint friend of the court brief supporting NetChoice and CCIA in both cases. According to Cato, there are many reasons why the law violates the First Amendment, but Cato's brief focuses on just one aspect of the Fifth Circuit's decision. Its reliance on the Pruneyard Shopping Center versus Robinson case, which the Cato brief describes as flawed. It says that, hey, the court shouldn't be relying on Pruneyard because it's a flawed decision. In Pruneyard, the Supreme Court held that California could force a private shopping center to host political pamphleteers on its property. The court held that there was no First Amendment injury to the shopping center because passersby are not likely to believe that the shopping center endorsed the speakers it was forced to host. But as the Cato brief explains it, there are many reasons why compelling a private entity to disseminate speech inflicts an injury. The false appearance of endorsement is one possible relevant injury, but not the only one. Supreme Court decisions before and after Pruneyard have recognized this fact, making Pruneyard, according to Cato, an outlier in First Amendment theory. For example, in Willie versus Maynard, the Supreme Court held that New Hampshire could not force drivers to display the state motto, "Live free or die," on their license plate. It did so despite the fact that drivers were highly unlikely to believe that other drivers endorsed the required license plates on their cars. Rather, the court recognized that a driver was injured simply by being forced to participate in the dissemination of an ideological message by displaying it on his private property. And before and after Pruneyard, the Supreme Court has held in several cases that it is a First Amendment injury to be forced to fund private speech of others. Here too, the harm is not in any false appearance or endorsement, but simply the compelled support of other speech that you disagree with. Cato's brief urges the court to overrule Pruneyard and fully endorse the more comprehensive view of compelled speech that underlines the Woodley and many compelled funding cases. Americans have a First Amendment right not only to refrain from speaking, but also to refrain from printing, funding, disseminating, staging, selling, or otherwise facilitating or supporting the speech of others. We have that right for many reasons, not just because we sometimes want to avoid associating ourselves as supporters and adopters of that speech. We also may want to simply avoid speaking ideas we don't think are worth spreading.
Yeah, thank you.
Okay, so I really like this question, but I don't want to actually answer the question. I want to use the question as an opportunity to reflect on something. I really like the question though, because for the last, I don't know how many years, teaching in a Georgia law school, my common law exams always included questions that involved Texas passing obviously unconstitutional law. Yet here I find myself. So, thankfully, free speech still reigns, and I can continue doing that. So, what I think is really interesting about this issue is, from the legal side, how this is something that really seems to turn on framing. This is something, we have a split decisions between the Fifth Circuit and the 11th Circuit about how to deal with these very similar Florida and Texas laws. This is not a legal dispute. This is a framing dispute. And I think that points to something really, really interesting. So think for a moment, consider for a moment, for those who are up on their recent constitutional law, for those who are not, I'll try to explain it a little bit, but consider for a moment two recently decided, very hotly debated individual rights decisions. Kennedy versus Bremerton School District and 303 Creative versus Atlantis. Both cases involved the confluence of free speech, religious liberty rights, and both cases sharply divided the Supreme Court based largely on justices' very different ways of characterizing the facts in these cases. Some justices described or defined or understood the facts in the Kennedy case as involving a religiously devout high school football coach offering private prayers of thanksgiving after games that a few like-minded players and parents occasionally would spontaneously join. And the majority of the court upheld his right to do so. Other justices on the court characterized the case as one in which a powerfully influential public school football coach generated significant peer pressure on students to join what effectively amounted to an extracurricular post-game team ritual. The only thing I know about sports, because I have 3 daughters, is that Taylor Swift will be at the Super Bowl next on Sunday. But all of my students who have ever played any kind of school sports have all said it's obviously the latter. If you're on a team and the coach is praying at the 50-yard line, you go pray. In 303 Creative, the majority of the Supreme Court saw a religious graphic designer being legally forbidden from expressing her deeply held religious beliefs. And other justices saw the exact same situation, but described it as religion being used to justify a public business engaging in illegal discrimination acts against a vulnerable minority that were in a way that's reminiscent of the Jim Crow era. I think we see something very, very similar going on in the decisions around these state laws attempting to restrict private internet platforms from how they can moderate and regulate speech on those platforms. The 11th Circuit Court of Appeals upheld an injunction against the enforcement of the Florida statute that prohibits social media platforms from deplatforming or otherwise marginalizing speech by or about political candidates. And the Fifth Circuit Court of Appeals overturned the lower court injunction against a very similar Texas law that prohibits social media platforms from censoring user content based on the point of view being expressed. To help justify its ruling, the Fifth Circuit characterized social media platforms as muzzling citizen speech and viewed the Texas law as an attempt by government to preserve a robust public marketplace of ideas. The 11th Circuit, by contrast, characterized social media companies as private entities whose ability to express themselves and their values through their content moderation decisions was under assault by overstepping state lawmakers who didn't like what the companies were really saying. What we have in these conversations, I think, is a fundamental different way of viewing things that is really very much illegal. These are deep, deep divides over two groups, two courts, looking at the exact same set of facts, or almost the exact same set of facts, and seeing completely different things. Given that, and I'll try to expand on this a little bit more in my response to the next question, but these are not legal problems that we're dealing with. This is something much, much more fundamental, and again, I don't think the solutions are really about law.
I'm the exact opposite of Professor Pill. I hate this question. And I'm also the exact opposite, because despite the fact that I hate it, I'll try to answer it, which I think will illuminate why I hate it. I hate it because there are two equally good answers to it. And one is that the government should regulate what social media companies should do because of the role that they play in our society. And the other is that the government shouldn't, because they're basically like publishers. And it would be crazy to think that the government can tell the New York Times or the Houston Chronicle what to publish or what not to publish. And so if you think of X, formerly known as Twitter or Facebook or Instagram, as like the New York Times or the Chronicle, then you say, oh, it's crazy to think that the government can regulate them. And on the other hand, I was saying in an earlier answer that the reason that speech matters is because ideally it leads to action. And so speech on these platforms can lead to action, and that action can be bad. And once upon a time, it didn't really matter that you could have false speech. And the reason that it didn't matter is not because the justices of the Supreme Court, and for that matter, John Stuart Mill, were right when they said that it's okay to have false ideas out there because you're also going to have truthful ideas and they're going to clash in the marketplace of ideas and the truth is going to prevail. That's not why it didn't matter. The reason it didn't matter is because it was hard to spread false speech in the way that it is today. And this is true even though in the 19th century, Mark Twain famously said that a lie gets halfway around the world before truth gets out of bed and gets its boots on. And that was true in 18-something. And if you think about where we are in 2024, the truth can never catch up with the lie. I mean, there are people who still think that the election was stolen. I mean, the truth can never catch up with the lie. And so the answer that is the opposite of the first one, which is no, the government shouldn't control the platforms because the platforms are like the New York Times and the Houston Chronicle and the Washington Post. The other answer is that we have speech protected by the First Amendment because of this idea that speech is essential to the proper functioning of democracy. What's the difference between living in the United States and Russia? Well, there are a lot of them, but one of them is that in Russia you can't say anything bad about President Putin because if you do, you go to prison. And why is that? It's because Russia is not a democracy. And in the United States, you know, you can call President Biden Brandon if you want to, and that's protected speech. Once the speech is not only failing to accomplish that objective of making democracy function better, but it's actually antithetical to that objective. It's making democracy function worse. I think there's a very strong argument for government regulation of these platforms. What those regulations would look like, I don't know. Whether it's a good idea or a bad idea overall, I don't know. But I think that one can very plausibly make the argument that democracy suffers if those platforms are not regulated and not controlled. And I think part of the goal of the Texas legislature and Florida legislature, if I were being extremely generous to them, is to make at least their version of democracy work better.
Thank you.
So I don't know if I love or hate this question, but I really do. I agree with Professor Dow. Let me just kind of quickly go through what I perceive to be the answers. If you bar social media companies' power to block content, do you take away their ability to regulate or restrict hate speech? Obviously, yes. So why would that be a good idea? should hate speech be regulated on social media platforms? That goes back to like hate speech. And what does that mean? Should we allow the owners of the social media platforms to regulate the speech themselves? Wow. The fox guarding the hen house. They have, it's interesting when you look at the cases in the Section 230 regulations that they are all exempt from. They are not liable for the people who post on their websites. It's kind of horrifying because some of the really horrific things that have happened are published there on their websites, and yet they have total immunity. That's pretty astounding. And I will tell you, I was listening to, I'm not going to say his name properly, the Google CEO, Sundar Pichai. Maybe that's close to right. Okay, thank you. And he was saying this, it was this morning, and he was having this conversation about regulations. And he was basically saying, well, we are a good company and we take this responsibility very seriously and we're going to do a good job at it. And I'm like, okay, that's fine. Maybe you are going to do a really good job and be really good at it. What about the next guy who has nefarious ideas for his web platform and is totally unregulated? And they don't care who puts anything on their website, and they can promote these incredibly false narratives and destroy people's lives literally, and there's no consequence for it. That can't be good either. You can't, I don't really think you can have the fox guarding the hen house. I don't really think that works. I think you have to have some regulation. It's a difficult, dangerous concept. And do I think Florida or Texas got it right? No. But there should be some really smart minds out there. We've got lots of professors here who can think about these things at length and come up with better solutions. But I totally believe we have to regulate them because the harms that are done are unfathomable to some of our individuals. It's just totally frightening.
Thank you so much. I'm learning a lot, and I'm taking a lot of notes. And I'm reminded also when we talk about the social media question, Mark Zuckerberg was on. He was before Congress last week, I think. And when I was thinking this project up many years ago, he was also sort of on trial before Congress. So this is a relevant question, and I appreciate all the answers. And there's some convergence, I feel, with yes, regulation. Of course, it's very complicated, and we have brilliant minds here. I mean, to go to your point earlier. Okay, I'm going to move towards the final question. I know that we're over time, but I think it's justified. The subject matter is so dense, and it deserves the attention that it demands. So I'll move towards the last question of censorship versus counter speech. In his book, The Harm in Hate Speech, Jeremy Waldron argues for a kind of First Amendment absolutism and asserts that hate speech should be regulated as part of a commitment to human dignity and to inclusion and respect for members of vulnerable minorities. Against this position is Nadine Strawson, whose book Hate, Why We Should Resist It with Free Speech, Not Censorship, shows that, this is quote, non-censorial countermeasures, including the kind of robust counterspeech that has been increasingly vigorous throughout the US, is more effective than censorship in advancing the causes of equality and social harmony, end quote. There are also, I'm going to abridge a little bit, I know there are pieces in the New York Times and in other publications where we have, certainly in countries like Germany and other societies, increasingly policing, but even prosecuting individuals who will publish hateful, and again, hateful, whether it's something based on their intent, or how close it is between how short is the chain of causation. I'm not so sure, but we're getting to a position where some societies, some contexts do actually prosecute what you post online. So anyway, to look at these two positions, censorship and counterspeech, the final question that I pose before the distinguished panel is, which camp is right? Of course, I'm going to pose it in this black and white way, but that's because I want to elicit a complicated response. Which camp is right? Is hate speech merely a form of free speech? And what are the costs of suppressing it or of allowing it? So, Professor Whedon, if you will.
Okay. Catherine O'Regan and Stephen Thiel of the St. Barnabaro Institute of Human Rights in the Faculty of Law, on the Faculty of Law at the University of Oxford, investigated international initiatives to regulate hate speech online. And some of the comments I'm going to make is based upon that investigation. O'Regan and Stephen Thiel highlight the difficulties of finding a widely agreed definition of hate speech and assess the legislative initiatives in 4 major jurisdictions to inform those engaged in a policy debate concerning the regulation of online speech around the world. The internet has allowed people across the world to connect simultaneously and has revolutionized the way we communicate and share information with one another. More than 4 billion people were internet users in 2018, more than half of the global population. In many ways, the internet has a positive influence on society. For example, it helps us to communicate easily and to share knowledge of all kinds of important topics efficiently. From the treatment of diseases to disaster relief, but the internet also had broadened the potential for harm. Being able to communicate with a mass audience has meant that we engage with politics, public affairs, and others. It's also changed. Helpful messages and incitement to violence are disseminated and amplified on social media in ways that were not even previously possible. Given the growing power of offensive and harmful speech online, many countries are asking themselves a challenging question: whether they should regulate speech online, and if so, how they should legislate to curb these excesses. Hate speech versus freedom of speech. The regulation of harmful speech online requires drawing a line between legitimate freedom of speech and hate speech. Freedom of speech is protected in the constitutions of most countries around the world and in the major international human rights treaties. Of course, we know that despite this widespread protection, many countries do not provide effective protection for freedom of speech. And caveat here, one of the dangers of regulating hate speech online is that it will become a pretext for repressive regimes to further limit the rights of their citizens. In countries committed to freedom of speech, it is necessary to develop a shared understanding of why freedom of speech is important. O'Regan and Thiel suggest that there are 3 main reasons why we value freedom of speech. Because we think being able to speak our minds is part of what makes us free and autonomous people. For democratic reasons, because we need to be able to talk about politics and policy freely to enable us to decide as equals how to vote, to hold those in power to account, and for truth-related reasons to enable us to refute false claims. Now, the U.S. differs from many other jurisdictions, being an asset in some important respects. First Amendment of the U.S. Constitution prohibits the restriction of free speech by government and public authorities. But there are exceptions for hate speech understood as speech that is likely to incite violence. So when we talk about hate speech, the court has recognized hate speech plus incitement. I mean, if you just talk about hate speech without incitement, and it's not in terms of causation, it's hate speech with incitement that is likely, very likely to cause imminent violence. You know, so that's the Brandenburg rationale. But it's not protected speech in that sense. So there's a causation factor, but it has to be very, very, very imminent. You know, and if it's so that we recognize hate speech in the Constitution plus, when you're talking about not protecting, it's hate speech plus incitement. If you're inciting someone, imminent lawful activity plus hate speech, and it's not protected. Now, there are narrow exceptions for hate speech understood as speech that is likely to incite imminent violence. The First Amendment, however, does not prevent private actors like social media platforms from imposing their own restrictions on speech. Social media platforms are further protected from private litigation because they are not considered publishers of content posted to their sites in terms of Section 230 of the Communication Decency Act of 1996. The United Kingdom imposed a range of criminal prohibitions on hate speech, both online and in print. The Crime and Disorder Act, Public Order Act, Malicious Communications Act 1980, and Communications Act of 2003 prohibits speech that is derogatory on grounds of race, ethnic origin, and religious and sexual orientation. The European Union has adopted the E-Commerce Directive, which prevents monitoring of content on websites before it's published, a provision which shapes and impacts the development of regulatory initiatives in Europe. The EU is exploring further options in regulating social media. So far, it has issued a communication on tracking illegal content online towards greater responsibilities of social media platform as it has entered into a code of conduct of countering illegal content online with Facebook, Twitter, YouTube, Instagram, Microsoft, Snapchat, Google, and Dailymotion. In terms of the code of conduct, these companies have agreed to take down any illegal content within 24 hours. The German network enforcement law, introduced just over a couple of years ago, imposed obligations on social media platforms to establish company management mechanisms which must work quickly, transparently, and effectively. Where unlawful content as defined by the German Criminal Code is identified, it must be removed or blocked within a specified deadline. Fines of up to 50 million euros can be issued for systemic failing in the complaints management system, including not consistently meeting the required deletion deadlines and ignoring reporting and transparency requirements. Our future directions say, in terms of online technology, regulating hate speech online is a major policy challenge. Policy makers must ensure that any regulation of social media platform does not unduly impair freedom of speech. Given the complexity of the problem, close monitoring of new legislative initiatives around the world is necessary to assess whether a good balance has been struck between the protection of freedom of speech and the prohibition of hate speech. In order for this monitoring to take place, social media companies need to be transparent about the content that they are removing and make their data available to researchers and the wide public for scrutiny.
Thank you, Professor Whedon. As we transition to Professor Peel, I'll remind everyone that if you have questions, actually, is Anusha here? I think she stepped out. Okay. When she steps back in, then we'll just prepare your questions mentally, and then we'll get the note cards to you.
So something Professor Doe said just a few minutes ago with respect to regulation of speech on online platforms reminded me of an idea. It's a principle that I was always very, very taken with. One of my longtime interests or legal interests
interest has always been the question of how or why it is that we justify in our democratic system a process by which unelected federal judges are the ultimate arbiters of what we can and can't do constitutionally. And there's an argument that's offered by John Hart Ewing, where he basically says that yes, this is a problem, and the truth is that sometimes we need to do undemocratic things in order to preserve the things that are necessary to preserve democracy. And so, as Professor Dow was talking about that in the context of online hate speech or regulation of online platforms, if it is indeed necessary sometimes to do the undemocratic or unconstitutional thing of allowing the regulation of speech on online platforms because that speech is so important and not regulating it really shakes the foundations of our democracy, maybe that's a appropriate price to pay. But that got me thinking about something else, which is really what I think we're all dancing around here. Excuse me, is what's going to save us? What is going to save us from the hate speech? What is going to save us from the disinformation? It seems to be an uncontrollable problem with very, very serious repercussions. And I think the premise of this symposium and the questions that framed this symposium in particular seem to be that law is going to save us. How can the law save us, or how should the law save us? But I think that it's important to appreciate that when it comes to law, I think we get the laws that we deserve. The founders, framers, the American founders, flawed as they were some of the only human beings, the very few human beings in the course of all of human history, that had the opportunity to try and create something from scratch the way they wanted to create it. Obviously, they had lots of baggage that they carried. They were British, then they were white, then they were male, and they were Christian or something like Christian, and so on and so forth. They couldn't really start from scratch. But to the extent to which they wanted to create a system that they thought is the right one rather than the one they were handed, they had an opportunity to do this. And one of the things that they observed in the process of doing this, and many of the founders observed this in different ways, was that law and government are ultimately social phenomena that are built on certain pre-legal, pre-political systems of social ordering, like religion, culture, morals, ethics, etiquette, etc. James Madison wrote that if men were angels, no government would be necessary. And I think the inverse of that is also true. If people are hell-bent on being devils, no form of government is going to prevent them from doing that, and no rules are going to prevent them from doing that. The rules are going to be interpreted the way they want to interpret the rules, or the rules will be thrown away. History has shown us that this is true again and again and again. John Adams said in a pretty famous letter that our Constitution was made only for a moral and religious people, and we can quibble about what that means exactly, but his point was that there are certain virtues that citizens need to have in order for this system of government to work. They need virtues like a willingness to sacrifice of themselves for the common good. They need integrity, they need honesty, they need charity, they need temperance, courage, reverence, prudence, and he went on. I don't know how many of these virtues he had, but he thought that everybody had to have them, or we needed a society of people who had these virtues in order for our system of government to work, because again, our system of government is one that is not going to save us from ourselves. And so I think all of these conversations about hate speech and free speech and regulation and censorship, etc., I think at the end of the day, again, as I've said before during this panel, this is not a legal question, or it shouldn't be a legal question. We shouldn't be looking to law to save us from these things. I think censorship is great. Censorship is an excellent solution to hate speech. Self-censorship. We should be a lot more careful about what we're saying and who we're saying it to, and not everything I think should I say, and not everything I say should I do, and not everything I say should I say loudly to every audience all the time. We should be circumspect and considerate and building the kind of civic virtues, and that's not a law job. The laws are not very good at doing that sort of stuff. So I I honestly think you're looking at the wrong people.
Got you.
You should have a different set of people
Yeah.
for this conversation.
Thank you, Professor Peel, for undermining the entire endeavor. And yikes, law doesn't solve the issue. And before I transition to Professor Dow, if you have a question, you can raise your hand. Anusha will come by with the note cards. And Professor Dow.
One of the first things that I said this evening is that I don't think that there's a useful definition of hate speech. And so I would like for one of the last things that I say this evening to be that I do think that there is such a thing as speech that has almost no value and maybe even no value at all. And it's not a lot of speech. It's an extremely small category. It's an extremely small universe of statements that have absolutely no value to the living of a good life, to the functioning of a proper democracy. But the question was, if you have to side with Professor Waldron or Nadine Strawson, Professor Waldron being, I think, the most elegant and eloquent proponent of the idea that hate speech is not protected, and Nadine Strawson being a former head of the ACLU who predictably takes the ACLU prediction that more speech is better. I would align myself with Professor Waldron because I think what he and I have in common, even though he would use the phrase hate speech and I wouldn't, is the recognition that there are certain speech that simply has no value. And not only does it have no value, but it's reprehensible. And it might not be a whole lot of speech, but it's some speech. And I think that that is speech that we as human beings and we as citizens of a democracy would be better off if we could not have ourselves subjected to it. And I'll just end with a lawyer point because I don't really disagree with Professor Pill, but I do not want to write off the role of law and lawyers entirely. And here's why. Donna was talking about the fox guarding the hen house, and I kept thinking about Fox News. And Fox News is never, ever again going to give a forum to people who it knows are speaking falsehoods because they just paid nearly $1 billion for doing that. And so I think that one thing that law and lawyers can do is to make the institutions like Fox, like Twitter, like Instagram, whatever the platforms are that are responsible for spreading not only falsehoods, because I don't care about falsehoods per se, but falsehoods that injure our democracy. I think that lawyers can help hold them accountable. And these are all businesses. And if you make businesses pay, they police themselves. And you know, people make a lot of fun of lawyers and tort lawyers and ambulance chasers, but that branch of the legal profession does as much as the government does to keep us safe from defective products. And I would turn the lawyers loose on the people who are propagating falsehoods, and I think that we'd be kept safer from them.
Okay, so law to the rescue. It's back again in the game. Final word, General Counsel.
Well, this is really out of my realm of I mean, I have an opinion, and I think I've probably conveyed it already. I think it's very important to have regulations over speech, like the internet, like these media platforms that are just have so much power that it's unbelievable. It's something we never anticipated. And to say that it's just free speech and we should just allow it and it should be unregulated is a really scary world. And one that I fear for our future if we let it go down that path. It's just it's a scary world if we don't. And I mean, and the only mechanism we have for doing that is the law and creating regulations and listening to the CEO of Google saying it's going to be fine because we'll take care of it. I'm sorry, I've just lived too long and I've seen too much, and there are bad people out there and they will continue to do bad things. And that is why we have laws.
Thank you very much for a very succinct end to our formal session. We have some time for Q&A. We'll have to cut it a little bit shorter because we went over. But again, I am learning so much, and I know that I speak for others when I say that this has been incredibly enlightening to see, especially lawyers, both speak about the law and solutions outside the law. It's very, very insightful. I'm going to begin by asking one question that we got from online, and I'll wait for the other. If the note cards are coming, okay, fantastic. So there's actually a lot of interest, and I'll begin actually in this case with General Counsel, if you don't mind. There's a lot of questions about the safe space. You mentioned safe space, and it's something again with this generation of students, it comes up a lot. I, as a professor, as an academic, as an administrator, I'm sympathetic to both sides of this issue and how thorny it may be. So if I can try and combine the many questions, in terms of safe spaces in the university setting, in general, what does that mean to students, and what kind of things are students looking for to feel safe? There are a couple of examples. So if a student is triggered by the Palestine teaching, or if they're triggered by a humanities course where they're critical of Christianity, or even, there's language which may be considered, mixing the profane with the religious. Even a case in my department, someone was triggered by a movie with a rape scene. So what does it mean to have a safe space, and what exactly are students looking for? I mean, or how can the university respond?
That's a better question.
Okay, yeah, I know.
But,
I got that from you, so please.
What students are really looking for is truly a space where they only hear things they like. And that's totally the opposite of what a university is. So obviously, we have to educate them to be tolerant of things that they don't like listening to, because that's really what makes them grow. How you get there is more complicated. Mm-hmm. And it takes a lot of time and energy of a lot of really, really dedicated student affairs professionals, counselors, try to educate our students that there is no real such thing as a safe space. Like, we don't, you walk out in the world, we all do, and everything is not a safe, friendly thing. And this concept that everything is supposed to be perfect and nice and, with a nice bow on it is false. We can't do that. The university can provide resources to help them deal with what they perceive to be a very negative experience. But I cannot, and we cannot keep it where they don't hear things they don't like to hear.
Okay. Well, that certainly reflects reality. As an adult, we have to deal with a lot of. Professor Berman, you have some questions.
I do.
Okay.
So this is a question following up on Professor Pill's discussion of sort of having the civic virtues is the solution as opposed to new rules. And so the question is, what kind of steps have been taken to inculcate those kinds of virtues and values in the minds of students? And I'll add, and what can we do as educators along those lines?
You brought it up. It's your question.
Descriptively, I don't know what's done on the ground. I mean, universities are great places in theory for that sort of virtue cultivation to start happening. In theory, and if we go back to law, once upon a time, the courts used to talk about the public school system as the place where we try to cultivate those virtues and those values. I don't know how well that actually happens anymore. I'm not really sure. Again, I think this is a matter. My point in my comment was that I don't think we're barking up the wrong tree if we're looking for systemic solutions to this. So where is it being done? If it's being done somewhere or somebody's in control of making sure it's happened, it's not happening. By definition, it's not happening. These are internal virtues that people have before the public school system starts inculcating them with values, or before some university starts inculcating them with values. And again, I think maybe there's something fatalistic about this, but again, we're going to get the system that we deserve. If we decide that we're going to be those kinds of people, then we're going to produce laws and government and culture and so on, where we get good outcomes that reflect the fact that we're all living out those values. If we're not going to do that, there's no one who can get us to do it, I think. There's no one who can get us to do it. Our parents can try to give us those values, and our schools can try to give us those values, and our churches and our social organizations and our country clubs and whatever else we do and whoever else we associate can try to build those values together. But ultimately, we have to decide to build those values together. If we're going to make the decision to do it, then we're going to do it. If not, then no one's going to get us to do it. Again, maybe that's a sad commentary on we're all doomed. I don't know. I like to be optimistic about it and think it can be done, and in many, many places it is being done, and you see it all over the place. The fact that Cato and the ACLU can be on the same side of this Texas and Florida law thing, it's like, oh, there's hope for something, right? Like, maybe the bar is very low, but right, the fact that the House of Representatives could reject an impeachment that was based on nothing, just because it's not based on anything. So why are we, conducting an impeachment? And by the narrowest of majorities, maybe there's a little glimmer of hope there. But that's a low bar, unfortunately. So.
Do you have one more question, or? I feel that maybe because of our time, I actually don't have a question. If you have one more.
Okay.
So one more question then.
So I'll combine a couple of questions. So these questions sort of push in polar opposite directions. And in some ways, I think it maybe revisits the fourth question. But so one question is, what if instead of making new rules, we chose to have less rules, less enforcement, and collectively refuse to stop people from responding in the ways that they might want to respond to people that spew bigotry. And then the other is essentially advocating for a constitutional amendment to ban hate speech. So is the solution do nothing or do more? So I don't know if that's...
Maybe Professor Whedon and Professor Dow, so yeah.
Well, I'm thankful that I teach my students oftentimes, at core, the law is only as good as the people enforce it and interpret it. Your job and your role is to argue for the interpretation. And there are such things. I believe that the core of America, we're a nation of laws. There are just laws and there are unjust laws. If you believe that the law is just, then support that as advocacy of free speech. If you think it's an unjust law, then challenge that law. But to suggest that laws, as someone suggested, laws are made for lawbreakers. If you can anticipate that we wouldn't have any lawbreakers, there wouldn't be any need for laws. I mean, one example of law might be the Ten Commandments, So people can have guidelines about what's expected, what's the conduct. And even though our Constitution may arguably be less than perfect, but it's a good start. It's a good way of giving us some guidance about what we can expect. We might fight about what freedom of speech is there, but it's there, and the protection of it. And the Constitution and the First Amendment is a dynamic concept. It evolves with time and culture, et cetera. But as the needs of society change, we fight about the interpretation. So the thought of depending on someone's moral character without guidance and laws, expecting and saying this is your conduct and these are consequences. I think the conduct ought to be good conduct should get good rewards. Inappropriate conduct should suffer the inappropriate consequences. But law gives us guidance to start, and we can evaluate laws, and laws may be subject to change. But the idea of just not having laws is a scary thought. The thought of each person being a law to him or herself, we may be deteriorating to that level in my view, but that's a scary thought. I think that society agrees, and we enact laws, et cetera, and then we can fight about whether or not those laws are just laws and continue to evolve as the need appears.
Professor Dow, do you want to comment perhaps on this question?
We've got this amazing telescope that's out there at a point between the Earth and the Sun. It's the Webb telescope. And nobody would have said that we can build that telescope and get it into orbit using an 18th century physics book. Okay. I really don't think that we should be looking to a document that was written in the 18th and 19th century to solve our problems today. So there are values that we have today that are present in those documents. But the idea that we're going to look to the free speech clause that was literally written at the end of the 18th century in order to solve a contemporary problem that was so far beyond what anybody at the time was capable of thinking about is ludicrous. So should we do nothing or should we do more? I would say that we should do something that is appropriate to the time that we are living in and that recognizes that we are facing problems that were not only not problems at the time these texts were written, but were unimaginable at the time that these texts were written. So yes, we should do something. Who should do it? It definitely shouldn't be politicians, you know. It definitely shouldn't be judges because they're too trained to put things in boxes. You know, I mean, if it were up to me, I would probably leave it to the novelists, you know. But I think that the most important point that I want to make this evening is that we need solutions to contemporary problems that we have in our contemporary toolbox, not that were handed down to us by people who have been dead for 6 generations.
Okay, I am furiously taking notes. Thank you so much to the panel. I want to end on a positive note. This is, of course, the new Center for Student Advocacy here at U of H, which seeks to create a, quote, brave space. This is a welcome comment. And no space is truly safe, as General Counsel mentioned, and that looking to be, finding a way to be tolerant and authentic is maybe, you know, I'll leave on that positive note. Something that is certainly desirable in our world, which certainly is dangerous, and we do need laws, and there are limitations, and self-censorship and the rest of it. Very, very well received. I feel, friends, that if this was my first, since I'm not a lawyer, if this was my first sort of entry into law school, this was like level 6,000 grandmaster, right, advanced level stuff. I've learned so much. I want to apologize, of course, we were not able to answer all the questions. Those of us who are here will still have an opportunity, right? With the reception, we can still talk and schmooze and talk business and pleasure, preferably the latter. I want to thank, of course, Dean Baines and the law school. I want to thank, of course, my team at Modern and Classical Languages. I want to thank, of course, you guys, all of the in-person audience, the Bunyuks once and always, as well as our virtual audience for their attention. And please join me one final time in thanking our panel.